Welcome to everyone, and welcome to what is in fact the second installment of the CAJO's Caribbean Law and Logic series. In this series, we seek to uncover mental models, reasoning frameworks, and foundational principles used by leading Caribbean jurists. Today, we have the great pleasure to have with us President of the Caribbean Court of Justice, the Honourable Adrian Saunders, who retires in a few weeks from the Caribbean Court of Justice and as President of the Court. Throughout this interview, I'm just going to refer to President Saunders from now on as Adrian, because we want to make this a relatively informal and relaxed event. A word about the CAJO. The CAJO, the Caribbean Association of Judicial Officers, brings together judicial officers from across the region, and we are a non-profit organization registered in Trinidad. Our first meeting and gathering of judicial officers took place in 2009. In fact, Adrian is the inaugural chair of the CAJO and served as such for 10 years, from 2009 to 2019. The current management committee is made up of judicial officers from across the region, and we provide a host of educational programming for regional judicial officers. This Law and Logic series is one such intervention. A word about Adrian. Adrian, of course, is a national of St. Vincent and the Grenadines, but also of Trinidad and Tobago. He is the third president of the Caribbean Court of Justice, and he is, if we can say, completely regionally grown. His LLB degree was from the Cave Hill campus, and he did law school at the Hugh Wooding Law School in Trinidad, graduating in 1977. He then entered into private practice, in which he practiced for 19 years, including establishing the firm of Saunders and Huggins in 1990. His judicial career commenced in 1996, when he was appointed a judge of the High Court of the Eastern Caribbean Supreme Court. In 2003, he was elevated to the Court of Appeal, and from 2004 to 2006, acted as Chief Justice of the ECSC. That should be from 2004 to 2005, because in 2005, Adrian was part of the inaugural cohort of judges that constituted the Caribbean Court of Justice. Adrian has also demonstrated a profound commitment to judicial education, and for example, he's been director and course director with the Commonwealth Judicial Education Institute. I've already said that he's worked with the CAJO as chairperson for 10 years from its commencement, but he has also served on the advisory board of the UNODC Global Judicial Integrity Network, and his commitment to integrity, not just in public affairs, but in terms of the judiciary and the function of judicial officers, is well known. Finally, as a way of introducing him and introducing this interview, Adrian is in his own right an academic and a scholar, and he has co-authored a very well-known constitutional text, Fundamentals of Caribbean Constitutional Law. Some of you may not be aware, however, that he is the consulting editor of the Caribbean Civil Law Practice, and both books are on display here as we go through this interview. He has also received an honorary doctorate from the University of the West Indies and is an Honorary Bencher of the Society of the Inner Temple. So Adrian, with all of that, welcome. Thank you. This is a busy time for you as you prepare for retirement. But I don't want to start by focusing on retirement. I want to start somewhere else, maybe many, many years ago, and to ask you a question that I think our listeners and our viewers be really interested in. What got you interested in law to start with, and kind of take us a little bit through your journey into the legal field, into becoming a judge, and maybe what and or who influenced you on this path?
Yeah. Well, first of all, thanks, Peter, for affording me this this opportunity. I do think it is of extremely great importance to tap the minds of retired judges, in my case soon to be retired, as you're doing, as CAJO is doing, because I found that unlike, for example, as obtains in the United Kingdom, in the United States of America, where you can readily see biographies of judges, you can readily get a sense of what animated judges of long ago. There's a dearth of that in the region. So I think this series is an excellent one. I saw the one that was done with Justice Burgess, and I really commend CAJO for doing this. As to what got me involved in law, as I pointed out at the special sitting, I got into law purely by accident. I was doing English, history, and literature at A levels. I was hopeless at the sciences, and there were some university scholarships to study at the University of the West Indies, but I didn't know what I wanted to do. I thought that I wasn't particularly enamored then about teaching, and if I did history, if I did literature, that's basically a recipe to come back to St. Vincent Grenadines to teach. And so in the scholarship application form, I left the field that required you to state the course of study you wanted to do. I left it blank. And the resident tutor, a gentleman by the name of Henry Williams, he was either at the time he was contemplating studying law by a correspondence course. And so he said to me, well, why don't you study law? There's a campus that has just been opened in Barbados. And I just shrugged and said, okay, well, you could put down law. But the thought had never occurred to me before then to study law, and I had no particularly great interest, no interest at all in the study of law. But from day one, I enjoyed it, and I haven't stopped enjoying it.
Yeah, it's interesting, isn't it? Because these accidents of fate, if you want to call them that, can have such profound impacts. Because, I mean, that was in the early 70s, I'm guessing,
Yeah, early 70s.
you know, and we were on many years later, and as they say, look at you now,
Yeah.
kind of thing, you know. On the path, so you get in there that way, but then you start to study law, you say that, you know, it was interesting to you, but of course you then set a practice. You're practicing on your own in St. Vincent and the Grenadines, I think, for many, many years. What was that like, and why the shift into a judicial career?
That has to do, I think, with my life experiences, my family background. As a lawyer in private practice, my practice, particularly in the early stages, was built on helping people. People who had difficulty navigating the legal system. I did a lot of pro bono work. And because I was a radical then and was a member of a pressure group, a social pressure group, I didn't have a lot of clients who were of wealthy means. They avoided my services in the initial stages. The down and out came to me. And that was born out of, I think, my parents' own life experiences. They were persons who were very involved in public service in one way or another. My father, in his early years, had been the president of the St. Vincent Teachers Association, was very much involved in trade union type activity for the teachers, although in those colonial days and with the teaching profession being a white-collar profession, it was not the same kind of agitation as exists now on the part of trade unions. But nevertheless, he was involved in the first strike, which teachers had ever been engaged in St. Vincent. And
did those things impact you as a relatively young person, young professional?
but
Those family experiences, that family context?
absolutely. That particular experience, the strike was in 1954, the year I was born, so that
Right.
I would
So it
not
was
have known.
anecdotal.
Anecdotal, exactly.
Yeah. Mhm.
But he himself always had a very clear sense of an appreciation for decolonization, for self-determination, for the fact that, and he brought us up like that no one was better than you, but you were no better than anyone else. That you needed to treat people with dignity, with respect, and that you needed to be fair. You needed to adopt an attitude to life, to your own approach to life that exemplified fairness. And I think that those values stuck with me. And what was good about studying law is that you could extract from the law those kinds of values, or you could infuse into the law those kinds of values. And it's one of the things that makes me really like the law.
I mean, we were coming into the shift to judicial officer, but before we do that, you said that sort of once upon a time you were radical, but I think as we go through this interview, we're going to maybe see that these early values and your radical approaches maybe never left you. But we'll see how that goes, because as I hear you speaking about these influencing values, certainly my own reflection of you in the law suggests that there have been consistent threads of what you've done. But just share maybe a little bit of what made you move from practice into the law, into becoming a judicial officer?
Right. So that as my practice grew, and it really did grow, it was initially a sole practice, and then I had the firm Saunders and Huggins. I found that, okay, you are earning a lot more, you're earning quite a bit. You are satisfying your clients, but what contribution are you making to your country? And I wasn't getting an answer to that question that I was comfortable with. And I thought that going on the bench would put me in a better position to make that kind of contribution, especially as I had given up on trying to make that contribution politically. I wasn't, in fact, a part of a political movement. And around the late 80s, early 90s, I recognized that I really wasn't cut out for that. And so I, in a conversation with a colleague, indicated that, I wouldn't mind at some point becoming a judge. I think I was then the secretary of the Bar Association in St. Vincent and the Grenadines. And somehow word of this got back to the Chief Justice, and he promptly asked me to join the bench. As I like to think, I was probably the last person in the Eastern Caribbean who was recruited on the bench by the proverbial tap on the shoulder, because very shortly afterwards, we moved to a transparent method of appointment. And that is how I became a judge. I left private practice in 1996 and was appointed to Montserrat and Anguilla. And then from there, first of all, I was appointed on a trial basis. I wanted to try it out, and the judiciary wanted to try me out. And after the first 3 months, we agreed, look, we need to be confirmed, and I was happy to be confirmed.
Yeah, I want to shift a little bit to something different. Before I do that, I just want to stay a little deeper or pause a little bit on something that I think I sense in what you're saying. And it has to do with, what, if I were to ask you, what about Caribbean society at that stage most influenced your worldview? So you're shifting from practice, a sense of, I want to do more for society to serve. Politics is not where I think I'm cut out to be. Let me move into this judicial role. But just to fill out this cultural milieu, what would you say were the kinds of prevailing influences then in Caribbean society that were meaningful for you?
I think I've always I've always had a Caribbean-centric worldview. I remember, and this is a very distinct memory, shortly after the Federation was dissolved, um, whenever I traveled in the region and you had to put nationality, I put West Indian,
Right,
until, of
yes,
course, there's a point where that couldn't,
yes,
that
yes.
wasn't being accepted. Um, but influences of the West Indies Federation, of the fact that when you're from the OECS, the idea of regional integration comes naturally to you because
Of course.
we in the OECS cannot provide for ourselves all the attributes of sovereignty. No one country has its own central bank. We have a regional central bank. No one country has its own Supreme Court. We have a regional Supreme Court. No one country has its own currency. We have a regional currency. So that you're forced to think along the lines of regional integration. And so as I went on the court, that was further cemented because the court, as I said, is a regional court, Eastern Caribbean Supreme Court. And moreover, you get to sit in each of the territories of the Eastern Caribbean. You get to have a better first-hand understanding and appreciation for the nuances in culture between and among the countries of first of all, the Eastern Caribbean, where I was between 1996 and 2005, and then, of course, here in
So
the wider Caribbean.
regionalism, this was almost an innate lived experience
Exactly.
of regionalism.
Yeah.
And that I get from you a strong sense of Caribbean identity. This
Absolutely.
idea that where do I belong? I belong to the region, to the West Indies, and so on. Yep, we're here with Adrian chatting about some contextual issues. And Adrian, you were sharing about your sense of Caribbean and identity and how these things have impacted you as a person and the way you think about law and society. You want to share a little bit more before we move on to your reflections now on the influences of these kinds of cultural factors?
Yeah, well, we were talking a little while ago about the fact that particularly the smaller countries of the Caribbean are unable fully to demonstrate, to realize their self-determination without help from each other and without some form of integration. And I really do think that it's not just the smaller countries, but the entire Caribbean would do much better in that long road to decolonization, to self-determination, by integrating with each other, by more functional cooperation, by taking advantage of all of the synergies that we could bring to each other. And I think that we neglect to do so at our own peril. Fortunately, in, first of all, CARIFTA and then CARICOM and then the CSME, we are getting closer and closer to a better appreciation of how we need to make use of each other's abilities and qualities and um, how we could get the best out of ourselves by functional cooperation, deepening functional cooperation with each other. And I think that the establishment of the CCJ is an extremely critical vehicle for furthering and concretizing that process.
Yep, and in sort of the trajectory of your life, I can already begin to see how, given your antecedents and the influences and where you started, to end at the CCJ in terms of regionalism and all of that just makes so much coherence in terms of your own life. But if we could just come to a little bit more of this idea of law and lawmaking and the idea of reasoning through complexity, because of course, as judicial officers and then at the CCJ, we're dealing with complex, often very complex matters. And if I were to, for example, invite you to share with how would you deal with matters that you consider complex, and in particular, is there an analytical framework that you find as you look back at your judicial career now that you've sort of gone to when you are faced with a complex legal problem or even a complex factual problem, maybe, you know?
Yeah. There is a notion that judges simply declare the law. The law is there, and a good judge simply finds what's there and articulates it, expresses it. And that may be true in 85% of the cases. But in the other 15 to 20% of the cases, the law is not clear. The law admits of several different choices, several different answers. And it is necessary for a judge to identify which of these several different answers is the most appropriate. What are the tools that we use to identify that answer, to adopt that path? You can't rely on what is the majority view, because then you don't need judges, you just need pollsters.
Well said.
What is the view that ought to prevail should depend on a number of different factors, and these are non-exhaustive. One, what promotes the values that are set out in the Constitution, which to my mind is an overarching framework for expressing the law? What is it that should promote democratic values? What is it that should promote the best sense of advancing the rule of law in the country? I think that those things are overarching in searching for the best answer.
And just to cut across a little bit, and you would say this would be a sort of a framework you would have brought, so that when you are faced with a complex legal issues, these are some of the things that are going through your own mind as you look at the facts and the legal issues that are coming before you.
Absolutely, yeah. Absolutely. And then there are some other factors that relate to the particular issues involved in the particular case. What is fair? What promotes a sense of justice? And what answer is coherent with the legal system as a whole, and also with the social system, with the goals, the aspirations of the society? And so that's the kind of framework that certainly I use in order to identify the answer to a complex problem. Some people would say that he's a judicial activist.
I wanted to ask you that. What do you say to those who accuse, because that's what it is, this is judicial activism, but it's also, just to put judicial activism in context, they will say this is a overstepping of constitutional boundaries. You are overreaching. And I think it's very important that you share your response to that.
You know, you hear that a lot, but we come back to the 10 to 15% of the cases where there is no clear answer. You have to give an answer. There is a case before you. There is a case whose determination is going to affect other like cases. You have to give an answer. You can give an answer which is in keeping with all of those models, all of those values that I just pointed to. It is going to change the law, because prior to you giving that answer, there was no answer to that particular issue. What do? Do you say, oh, well, it is for Parliament to change the law, so I'm not giving an answer? When in fact, an answer is required, and you are charged with providing that answer. To me, my responsibility is to provide the answer. As long as I do so with integrity, as long as I do so in keeping with a respect for the role of the other branches of government, as long as I do so in a manner that is coherent with the legal system as a whole, that in a manner that is objective. That is to say, I don't give a subjective answer in keeping with what I want, what I think, but rather I give an answer which I think is in keeping with the legal system, in keeping with what is required in the circumstances, irrespective of whether it is my own subjective view or not. I give an objective answer. If that is labeled judicial activism, guilty. I honestly think that that is my role as a judge.
Adrian, let me press that a little bit, because the constitutional framework of unelected judicial officers is the model in the Caribbean, in the independent Caribbean states. So is it not that that exercise of independence is actually within the four corners of the constitutional framework that we run, and therefore consistent with the separation of powers? And so this suggestion that somehow you are acting out of your role is a flawed criticism, because what I think I hear you saying is this is exactly the role that the constitutional framework calls us to play.
I couldn't agree with you more. The reason that you have judges, and the Constitution explicitly says so, judges are there to interpret the law. And so I quite agree with you that it is a part of the separation of powers that in these hard cases, in these complex cases, in these cases that require interpretation, that judges render that interpretation. You take a case like Spence and Hughes, which is a case where the Eastern Caribbean Court first declared that the mandatory death penalty was unconstitutional. Or you take a case like Nerves, which decided that the savings clause in the Barbados Constitution should not be interpreted in a way that will allow colonial laws that were inconsistent with fundamental rights to prevail over the enjoyment of those fundamental rights. When the judges in the Eastern Caribbean Court said, no, the mandatory death penalty should be a discretionary penalty so that judges should determine in which cases a person should receive the death sentence. And when the CCJ said that the savings clause cannot be interpreted in a manner that would allow colonial laws to supersede human rights, to me, those were perfectly logical decisions. In Nevis, for example, you have a Barbados independence constitution. This is a constitution that proclaims Barbados's independence from colonial rule, from colonial domination. It is a constitution that sets Barbados on a path to self-determination. It is a constitution that says, from now on, the people of Barbados are going to determine their own destiny. Those values are contained in the Constitution itself. And so, to juxtapose those values against colonial laws that are inconsistent with those values, and to say, well, I'm sorry, I would have to allow the colonial laws to contradict those overarching values, that's a problem for me. And as a judge, I think that it's not just a problem for me as an individual, it's a problem for me as an interpreter of the Constitution.
In an independent Caribbean society.
In an independent Caribbean society. I cannot be a judge expressing the views of the judiciary in an independent country where the Constitution expresses clearly that there are these human rights that individuals must enjoy. And when a person comes to the court to say my human rights are being trampled upon, I tell the litigant, I'm sorry, I can't do anything about it, because a law which was not made by the Barbados legislature, but rather was made by the colonial legislature, says you cannot enjoy those human rights. I don't see that a court should give that kind of answer. And that is typically the kind of response that some persons label as judicial activism. To my mind, all that it is a court, a judge determining how best to interpret the Constitution in cases where there are ambiguities. What tools do you use to resolve these ambiguities? Now, there's a difference between judicial activism and judicial overreach. Judicial overreach would be a situation where the judge does not make that kind of analysis, but rather the judge gets a bee in his or her bonnet and determines, irrespective of any analytical tools that have integrity underpinning them, that the judge will take a decision that is whimsical, unreasoned, stepping on the bounds of the legislature, or in some other fashion, totally at variance with any logical or reasonable appreciation of what the law requires.
And so just to drill a little bit down on that, and so that judicial officers who are engaged in this work should maybe have a duty of accountability and transparency. That is to say, to be transparent and accountable as to their methodology. So, for example, in Nevis, you and the court, certainly by majority, were very clear that when we read the Constitution, you say we have to recognize there's a hierarchy of values. So that is your methodology. So that even if there are clauses in the Constitution, all clauses aren't equal. And you then further in the exposition of that methodology say human rights provisions are to be privileged. And so I'm using that as illustrative. And so would you also say that not only must the judges be engaged in this kind of analytical work, but they also ought to be transparent about the methods that they are developing and using to execute this work?
Absolutely. And all of that you've just set out is part and parcel of judicial integrity, of being able to reason your decision making in ways that clearly set out why you do what you do, and allow readers of your judgments to appreciate how you arrive at your decision.
And that's what makes it objective, won't you agree?
That's
as opposed to being
subjective,
pure, yes, yeah.
purely whimsical,
yes.
It's just giving vent to your own predilections.
Yeah.
You take a case, for example, like Joseph and Boyce. One of the issues in that case was there is a clause in the Barbados Constitution that says that the Barbados Privy Council, or the Mercy Committee, their decisions cannot be inquired into by a court of law. What the lawyers call an ouster clause. You oust the jurisdiction of the court to inquire into the decisions that they make. But suppose the Barbados Mercy Committee says, we will afford mercy to all persons who support the BLP, but not the persons who support the DLP. Person who supports the DLP applies for mercy, they don't get it, they come to the court. Are you going to say that, well, there is a clause in the Constitution that says the decisions of the Mercy Committee cannot be inquired into by any court of law? So I'm very sorry. I feel your pain. I understand that you have been discriminated against, but I can't afford you any relief. Now, it would be a very poor judge that takes that decision, even though there is a clear provision, as clear as night as day, that says in the Constitution that the decisions of the Mercy Committee cannot be inquired into. You look to, as I say, to resolve that problem to the layered values that exist in a Constitution. And there are provisions in the Constitution that protect against discrimination. And you see, well, those provisions have a greater value than this provision that seeks to oust the jurisdiction of the court. And therefore, where these two sets of values, these two provisions are in conflict with each other, you give precedence to the one that affords persons their human rights. Because fundamental rights, human rights, are at a very high rung on the ladder of the values that exist in a constitution. And so very often these are the things which you hear persons being accused of being judicial activists. But in truth and in fact, there is a rationality about the reasoning process. There's a transparency about it. And underpinning the reasoning is a logic that can explain itself.
You know, I'm happy you use the examples of Spencer and Nuve and Boyce, because I think they're so illustrative of what we're talking about. I just want to sort of move into something that maybe is a little more controversial, and then also something that broadens out this conversation a little bit. Let me start with the latter, the broadening out. And this approach in terms of interpreting the Constitution per se is fair enough. But when we come to what, let's call it, ordinary statutes, doesn't the same approach or framework apply, or does it for you, in the sense that even when we look at an ordinary piece of legislation, we, if required, if there is an ambiguity or uncertainty, we should also be looking at how do the competing options line up with, let's just say, constitutional values and, where relevant, international values. Would the framework for you that you've described also apply in that way to the interpretation of ordinary legislation, where there is, of course, ambiguity?
It certainly does. It is impossible for a parliament to draft a law that perfectly covers every conceivable situation now and in the future, because society is dynamic and it is beyond human capacity to conceive of all the nuances that will occur in the future and make provision for them, so that over time, statutes, sometimes it's difficult to interpret them in a way that makes sense given the dynamism of society. And so courts again are faced with the dilemma of how do you make sense of the statute? And sometimes you go to the mischief rule. What is it Parliament intended to cure? What is it Parliament intended to do here? A case we did here at the court, which some people have a problem with because they say that the CCJ can't count. Selby and Smith. This was a case of succession in Barbados. The Barbados Parliament went out of its way, I hope I remember all the facts clearly, to ensure that persons, particularly women, who live with men in a common law, what we call a common law relationship, over a particular period of time, are able to inherit from the man if he dies before her, provided the man was single. Now, this lady was living with a man, and the man had been married while they were living together. Very shortly, they lived for a long time. Clearly, his first marriage was not successful, and he entered into a common law relationship with this other woman. But he was still legally married to another woman. And then shortly before he died, he got a divorce. The qualifying period for the common law spouse to be able to inherit, I think it might have been about 5 years. But he got the divorce less than 5 years before he died. But he had been living with the lady for a long time.
Well over 5 years.
Well over 5 years.
Mm-hmm.
Up comes the deceased, he didn't make a will. Up comes the deceased brother and says, this lady, common law wife, is entitled to nothing because he was a single man for only 3 years, and therefore you don't qualify because the legislation provides that you have to be single for the 5-year threshold must start. Well, the legislation doesn't say so, but the argument was that the 5-year threshold must start from the time of your divorce. And there were a lot of views expressed by persons in the society that the CCJ can't count. The 5-year period must start at the time he got the divorce. And we said, no. The 5-year period must begin when they begin living together, provided that on his death, he is a single person. Because the whole idea is to give relief or some protection or make some provision for a common law spouse. This lady was a common law spouse for well over the 5-year period. And the man did the responsible thing, which he could have done 10 years before, but he didn't. But at the time he died, he was single. The long and short of it is that we thought that where there was this ambiguity in the law, we should focus on what was right. What is it that Parliament wanted to secure here? And what Parliament wanted to secure here, in our view, and based on the Hansard, was that if two parties live together for over the qualifying period, once the man, in this case the man, is single at the time of his death, that the surviving spouse should be able to inherit. And we gave that decision.
And it throws into relief, and I think that's part of this whole conversation that we started with activism and so on, between a sort of a more textualist approach and a purposive approach. And would you say that it is a reasonable observation that one of your prevailing sort of frameworks for analysis is to take a purposive approach as your go-to approach where there is some uncertainty, obviously, because if there's no uncertainty, then it doesn't arise. But is it then that in this sort of tension between a textual approach and a purposive approach that for you, over the course of your judicial career, that has been, I don't want to say a default framework, but a prevailing framework for you? What is the purpose? What is the intention? How would you frame that for the viewing audience?
But first of all, I would say that a textual approach is also one that has integrity, and that one, in certain situations, should be used. If the text is clear, if, for example, we are dealing with if you have to interpret, for example, an agreement between commercial parties, properly lawyered up, they write what they mean what they write, then you go by the text, and the chips fall, the chips would lie where they fall. So that is an example of a situation where you use a textual approach. Where you have dilemmas that have to do with social relations between persons and the state, or that has to do with how we address knotty problems concerning the country's cultural traditions, then a purposive approach is particularly important. It is important to understand the history of the situation. We take a case like Bisram, for example. This is a case from Guyana that dealt with interpreting a law that was passed in the 1890s. This is a law that said that the DPP, the law referred to the Attorney General because there wasn't a DPP then, but it's now the DPP, can argue a case before preliminary inquiry, present a preliminary inquiry before a magistrate as counsel, and if the magistrate gives a decision that no case has been made out and discharges the accused, the magistrate, the DPP can then go to her office, type up a letter instructing the magistrate to rescind that decision, to recall the accused, and to commit him for trial. Now, we have obvious problems here with the separation of powers. We have obvious problems here with judicial independence. This was a law that was passed at a time when magistrates would have been lay magistrates, when the Attorney General may have been the only legally qualified person in the public service. And therefore, one can begin to understand the reason for a law like that. In the 20th century, in the 21st century, you have to look at that law within the context of all the prevailing realities. The magistrate is a legally qualified person. You have an independent constitution that declares judicial independence as a supreme value. You have a constitution that honors the separation of powers, and therefore that law can't stand. And it is the duty of a court not just to wait for the legislature to do something about it, but to declare the law to be unconstitutional, to be inconsistent with the Constitution, as we did in that case.
Yeah, no, and I think the Bisram example really shows the sort of complexity that is required, especially as you move up the ladder, as it were, and you move to whether an appellate court or apex court, to what are the considerations that we use to try and resolve these kinds of issues. It no longer becomes as simple as what do the words mean and how do you apply it. Not that that's not important, as you've explained, but what you've just pointed to is social context and how social context informs meaning originally, and also how it is relevant for current meaning and interpretation.
You know, Peter, C.L.R. James, one of the great Caribbean thinkers from Trinidad and Tobago, I like to put it that way, a great Caribbean thinker from Trinidad and Tobago. He once wrote a book, Beyond the Boundary, excellent book, not just about cricket, but about culture, about arts, about society. And he has a quote in it where he says, "What do they know of cricket who only cricket know?" And I say the same thing to judges, to lawyers, about the law. What do you know of law who only the law know? You can't understand law if you don't understand the society. You cannot interpret law if you don't have some grasp of history, if you don't have some appreciation of how society has progressed throughout the years, where it has come from, where it is now, where it is aspiring to go. And this is why I think there's much to be said, I put it in a positive sense, for lawyers to be exposed to other disciplines other than law when they study law. In some countries, you can't get a law. You don't study law unless you first have a first degree. And there's a good value for that, because you have persons who leave, like I did, like probably you did, high school, and you study law, and more law. I don't think you did that. But you do that and you come out conceiving of law as a self-contained element, divorced from the society, the culture, the traditions, the aspirations. And if that is how you conceive of law, then you would not be a very good lawyer. And you would be an even worse judge, because law reflects society. And to properly understand law, you have to have some understanding of society.
Just to quickly segue, because I think this is such an important point, because I want to come to, what would you say to judges who are newly appointed and to attorneys in terms of preparation of cases and so on. But I want to lay the framework for that movement by asking you about this, because you have cited C.L.R. James, right? But how do you value reading Caribbean literature? How do you value reading Caribbean novelists? Forget about for the moment the sociologists and so. In other words, how do we as Caribbean judges, how do you as a Caribbean judge, how for you has the reading of these extrajudicial resources impacted you and the way in which you make decisions and so on?
Tremendously so. As I said, you would be a much better lawyer, a much better judge if you read very widely. And you read anything, literature, history, Caribbean novels. You need to understand your society. And unless you do, then you wouldn't be able to best understand why laws were passed, how they functioned in the past. Law has to be stable, but law has to move. It has to change. There is this reciprocal relationship between stability and stagnation. On the one hand, law has to be stable. On the other hand, it has to evolve. It has to change. And so we want both stability, but we also want evolution. We don't want chaos. We don't want a decision like Nervais or like Joseph and Boyce or like Spence every Monday morning. But every now and again, there comes a point in time when the law must make little leaps in order to reflect, to continue to reflect life.
And just to pause there, I mean, people hearing that may think, well, oh my, that's not the role of judges. But would you agree that in fact that is in the deepest traditions of the common law? That the whole tradition that we practice in the Anglo-Caribbean is a system of the incremental development of the law based on existing law to meet changing conditions. And so there's nothing about this that is so outside of the boundaries, to keep the CLR James
That's
analogy,
right.
We are well within the boundaries. Would you think?
No, exactly, and I agree entirely with you. It is part of the role and function of a judge, precisely to play that kind of role. Now, you have to do that role, you have to play that role with integrity, with transparency, without overreaching. And that's the tension that always has to be kept. You have to balance that tension to ensure that you function within the four walls of one's remit, where you are sensitive to what the role of a judge is. You're sensitive to the role of the legislature, but you're also appreciative of the fact that constitutional values and ambiguities need to be interpreted in ways that allow the law not to stagnate, not to deprive people of their human rights, and at the same time give due weight and respect to the role of the legislature.
Yeah, we've covered a lot of good ground with frameworks and so on. And what I want to do is to take a little shift and to put you in the role of mentor, because you're close to retirement, not quite there yet, but you're close to retirement. And so, long judicial career, long legal career, very esteemed, judicial educator for decades and a passion for it, etc. From where you sit now, from where you are now, what advice would you give to attorneys, whether junior or senior, or judges, in terms of the development of Caribbean jurisprudence? I don't want to say how to write better submissions. I prefer to put it a little more generally and allow you to share maybe some advice or some thoughts for them, for us to consider.
so far as, let's deal with them separately. As far as attorneys are concerned, apart from reading outside the law and reading voraciously outside the law, I think that lawyers, okay, but when I went on the bench, it occurred to me that I know much better now how to advance submissions before a court. You pick up little things that you understand now why judges react in the way in which they react. So many things that, okay, let's look at it from the standpoint of so many things that irritate judges. Gilding the lily. You know, you make a point, it's a good point, but sometimes judges are responsible for that too, because they don't, whether subliminally or expressly, give a hint to lawyers, well, you can move on. But very often lawyers fail to take the hint to move on, and they go on and on and on about a point that is already fully appreciated and understood. In judges, I don't like to see in judgments long quotations of text from previous cases. Everyone can read, so it only is necessary to summarize a passage, give the reference, and not lengthen, you know, the judgment by pages of quotations. I'd have to think a lot more to give you answers to that particular question. But certainly having a better understanding of Caribbean realities is critical for both lawyers and judges in order to understand the law and to put forward arguments for this or that interpretation in a hard case.
And would you say, looking back again now over the years, how would you say Caribbean jurisprudence has evolved? Is it evolving? Do you find that, do you see a shift from when you first started on the bench to where you are now at this point in retirement, that there is generally an evolution in the region around something that can become a Caribbean jurisprudence? And maybe what does that even mean for you, this idea of a Caribbean jurisprudence, looking back now?
I think that CAJO, CCJ, and its decision-making have played a very helpful role in forging a sense of, among judicial officers in the region, of having a mission of furthering Caribbean jurisprudence, of better appreciating that we have our own aspirations in the Caribbean, we have our own culture in the Caribbean, we have constitutions that are basically similar in terms of the structure with some differences, and we have a responsibility to flesh out the values in those constitutions in ways that respond to our Caribbean-ness. I think that over the last 20 years, we have gotten a much greater appreciation of this on the part of judicial officers. I think too that there has been a lot more judicial decisions given by Caribbean judges that are shared among ourselves and that serve as precedents for each other, and that helps to build this common understanding of our Caribbean jurisprudence. I think that the very existence of the CCJ as a final court has ensured that throughout, even in those countries that do not send their final appeals to us, it has ensured that there is a counterweight, so to speak, to jurisprudence that comes out of the Privy Council, which sometimes may not have the thinking or the experiences of Caribbean people that would animate it. And therefore, I think that, you know, we are much further along the path of forging our own Caribbean jurisprudence than we were 20 years ago, naturally.
Yeah. As we kind of wind down, three things. One, hope. Is there from, you know, do you have a sense of hope for the Caribbean jurisprudence we're talking about and the CCJ? One. Two, anything about your legal reasoning that you think has been misunderstood? May not be that, you know, or about you as a jurist that you think may have been misunderstood, that you would like to say something about? And any final sort of insight? So, question of hope, question of anything that you would like to say, and and wisdom and insights in terms of, you know, maybe even legacy. If there is something in your whole judicial career that you would like to be remembered for, what could that be? And I'll come back to them, because I've thrown three questions at you, and maybe it's a little unfair at the end.
In terms of hope, I really do believe that the establishment of the CCJ is one of the most profound decisions that Caribbean leaders have made. The CCJ is here to stay. The fact that only 5 of the 11 eligible countries send their appeals to us, I'm not particularly fazed by that. Disappointed, yes, but I think that those 5 that send their appeals to us, and the countries, people of those countries that send their appeals to us, I think are enjoying an advantage over those that don't. That's a self-serving statement, but I truly believe it. And the work that they send provides the CCJ with enough material to continue to fashion a Caribbean jurisprudence. The work of CAJO and the CCJ Academy for Law, and the work of the various judicial education institutes throughout the region, all help to cement that work that is done by the court, I think, by the CCJ, so that I am very optimistic about the future of the court and about the future of our determination to deepen and broaden our Caribbean jurisprudence. About my own modest body of work, I do what I have to do.
Some people will disagree. They won't say it's modest at all. We started with you being a bit of a radical, and you sort of disavowed it. I want to suggest that the thread of the corpus of your work demonstrates, Adrian, I wouldn't say radical, but I would say independent, innovative, creative. Yeah, those are the words I would use, you know, but
yeah, well, thank you.
What would you take, what would you like of all that you have done? You know, so it's not so much maybe about, you know, remember me for being great, as opposed to something that you think matters to you, that you would like to see
I think that
continued. Yeah.
Judges need to be bold.
Yeah.
Need to be brave. I remember in my first or second year on the bench, I look back on it now and I smile. I gave relief to a listener for the breach of his freedom of expression, because I thought that the government had taken a heavy-handed decision to cut off a radio program. And this guy used to listen to the program regularly. And he joined the host of the program in complaining about the breach of his freedom of expression. And the Constitution of Anguilla says, well, you have the freedom to receive ideas. And I said, well, he was receiving ideas. And so I said, yes, your constitutional rights have been breached. And I gave him relief. I gave him a declaration. And I've never seen that done before or since. But to me, that was what was necessary and just. In Lucas, where I was a dissentient, I gave the applicants, this is a case from Belize, I gave the applicants, I thought that this should have succeeded. And among the relief that I would have given them, I would have ordered the Minister of Education to apologize to them. So I suppose what I'm trying to say is that one of the things that I think have characterized what I have done, what I tried to do on the bench, is to go where I haven't seen anyone else go before, because I think that that is the proper path to go. I have a job to do, and I feel that I must do that job, even if there's no precedent for it. If I am satisfied that on a fair and objective consideration of the Constitution or the law or the material before me, that is what is required, or that is what is fair to do. And I think that judges should do that. The last question was in terms of what again?
Any special insights, but I think maybe anything, just the opportunity as we speak to a broad listening audience of many people, any special insights that you would, or any insight at all, anything you want to share? You reached the pinnacle, Adrian, in so many ways of so many things.
Reached any pinnacle.
Well, you have.
No.
The modesty is a trait, but the objective reality, the evidence suggests that you are retiring as the president of the CCJ, which is
there's
a lot of experience.
Watchwords which we mentioned earlier. Objectivity, fairness, integrity, transparency. I think that both judges and lawyers, if they are guided by those values, by those principles, you could never go wrong. Humility, and a sense that being a lawyer, being a judge, places one in a very responsible position in society. And it's important that people, those who occupy those positions, understand and appreciate the weight of responsibility that goes with occupying that position. I remember distinctly when I was first appointed in 1996, I spent many nights weighing that enormous responsibility. Steeling myself to try and discharge it in ways that are faithful to the calling of the office. I think each judge needs to reflect on that often, because it is an enormous sense of, an enormous responsibility. that should humble you, because people's lives sometimes, whether they go home and enjoy their family or sit in a prison for 3 years, 5 years, 10 years, it all depends on your decision making. And therefore, you need to ensure that you give decisions in a timely fashion. You need to ensure that you give decisions that are fully considered. You need to ensure that you give decisions without prevarication, without looking over. Once you make a decision, you've made it. I know some judges get paralyzed about making the decision because they're thinking about the consequence of the decision. That's not a bad thing, to think about the consequence of the decision. But once you have to come to a decision that the chips must fall where they lie. And once you're satisfied about the rightness of your decision, then you must make it, and don't let the decision-making process paralyze you. And that is the reason why some judges don't give timely decisions, and that is unfortunate, because if you're not on the CCJ or at the Privy Council, then you're in the happy position that there's a court above that would correct the mistake if you've made a mistake. But it's important to be decisive.
Well, thank you very much. Clearly, I think we've all enjoyed so much of what Adrian has had to share with us, so many insights, so many explanations. But my big takeaway, Adrian, from all of this is the idea that, and I think it comes back to the listener's case, the idea that you have been so willing to have the integrity and independence of what you believe is fair, right, and just. And before we go, therefore, the last thing that I want to bring you to, because in a very real sense, both in Caribbean and international spaces, it's the question of the day. And that's, what are your thoughts on AI and, that cliche, the future of courts? But you've been journeying with AI as president of the CCJ and personally, and how would you speak to that? And not in maybe great length, but just share a few thoughts as we close.
Generative AI is a game changer. And and I'll speak for myself, I do not fully comprehend all its ramifications and ways in which it will interact with and influence decision-making processes. There are some aspects of it that you can already see. I use AI. I use it liberally. I use it in helping me in preparing speeches. I use it to help me to summarize documents and so on. But it does a whole lot more. I don't think we can avoid the use of AI. In fact, there are very many beneficial uses of AI. I think lawyers in particular have a responsibility to ensure that any AI-generated response they get to questions they ask of AI need to be verified before they're submitted. We've had some cases on this, but it is something that we need to monitor. We need to not be afraid of. We need to embrace to the extent that we can find ethical uses of it, and we just need to evaluate how we use it as the time goes on.
Mm-hmm. Well, on this note, we're going to come to a close, and all that I want to say is, Adrian, thank you very much for being willing to engage in this conversation, for sharing everything that you've shared. And to all of you who are listening and viewing this, we hope that you will reflect deeply on what Adrian has shared. This has been a sharing based on long and deep experience, on reflection and introspection, and maybe most importantly, from my point of view, from a person who I consider to have the highest integrity, sincerity, and authenticity as a human being, but also as a judicial officer. And so, until our next installment of the CAJO Law and Logic series, to all of you, thank you for viewing, and thanks once again, Adrian. The last word is yours, if you want to say anything to the viewing audience.
I want to thank you for this opportunity, as I said at the beginning, and I think this is an excellent series. Thank you.
Thank you very much. Good day to everyone.
Good day.